a very warm welcome. My name is Adam Formanek and I'm the head of international projects at SIBB. And I'm very happy to welcome you at this workshop, which is regarding IP strategies, implementing and building them for deep tech entrepreneurs going international. First of all, I would like to make you aware of the tool that we're using. It's called Remote Conference. And in order just to profit out mostly of this tool, please make sure that your camera and microphone is working. If you're having some technical difficulties, in the left-hand corner, there is the menu drop down. So please make sure that you just turned on the camera and the microphone. Our speaker just did it, and this is a good sign because he's very well prepared for that. So I would like, first of all, just to mention that today this event is organized by SIBB and the project Deep Tech Hub. Regarding SIBB, I will shortly play you a video which is actually going to introduce you to our activities, so I don't have to explain it that much. So please share this video with me for 2 minutes, and then I will be shortly presenting our great speakers. So thank you very much. This was an introduction to our association and what we are doing. One of our projects is Deep Tech Hub, and I hope you understood that we are actually, as an association, as a cluster, developing a lot of technological enterprises. We have a scholarship, an accelerator, we have funds for startups, and also we have events that are actually dedicated to founders and matching founders with them. But what's the biggest deal about a deep tech project? It's actually that we are just trying to match not only partners, but also the know-how. And very important for today is something that we wanted to organize before starting on deep tech entrepreneurship between international partners, is a practical guidance into the world of IP, intellectual property applications and strategies for deep tech enterprises expanding to Germany, Poland and Russia, because this is the focus of our project. As you know, deep tech is not just a business model innovation, but rather an innovation in the science or technology around which a business might be created. This is how a business or startup that is built on deep tech distinguishes itself from companies such as Facebook, Spotify, Uber, or Airbnb. These are just technological platforms. But deep tech companies own their intellectual property, spend years on testing and research, and have international scientists, engineers, or other experts on their teams in addition to the core business personnel. Deep tech companies win by out-innovating the competition and by building the best products, but they often rely on protective and preventive intellectual property strategies. Understanding the intricacies of intellectual property is vital to both innovators and investors. And although Germany and Poland are EU members, new enforcement rules for IP rights can change significantly the approach prices to cooperation with international partners. So our platform for international cooperation, Deep Tech Hub, helps you to develop the potential for cooperation between startups, investors, and companies from deep tech sector in Germany, Poland, and Russia. And this workshop is going to be focused, a webinar on our project as an introductory guide into the world of IP applications and strategies for deep tech enterprises willing to cooperate with strong ecosystems within EU like Poland or non-EU like Russia. I've got great speakers today. I'm going to be talking about intellectual property and know-how, how you can shape the IP framework for your deep tech cooperation, and what should you consider for the confidentiality and non-disclosure agreement. Let's welcome on the stage our first speaker today, who is, I'm very, very happy to welcome Mareike Christine German, who is a salary partner at the company of Taylor Wessing, a very famous law firm here, also in Germany, based in Düsseldorf. Welcome you on the stage, Mareike.
Yeah, welcome, and thank you very much. And
exactly. One more organization, Mareike will be presenting with a presentation. If you would like to have any questions regarding the technique or something's not working, please just make a question and take a question in the chat. If you have any questions to Mareike, use the Q&A question. We will be more than willing to answer that. Have fun.
Yes, and before that, we have a special topic here because I'm not alone. Also, my colleague Sebastian Fischöder is coming. Must he come up to stage?
I'm sorry, exactly. Sebastian Fischöder, who is actually a law master in Trinity College Dublin, also from Taylor Wessing. So I'm sorry, I just forgot that it was actually a presentation together.
No problem.
I thought I wanted to present you as a second speaker, my fault, but you're on the stage, you're both here. So this presentation is going to be held by two experts. Excellent fun. Thank you very much. Enjoy.
Thank you very much. Thank you. So, hello all. Yeah, thank you and well, welcome here at the great webinar here at SIBB. And yeah, we have a special and interesting topic to discuss, and I hope later on we have a discussion on that with you. And I'm happy to be here also here with other great speakers from Poland and Russia. So I think we will have a great time. Well, what do we want to discuss? We want to discuss how can you, or should you, in the field of deep tech innovation, can manage your rights and know-how, and how you can protect them, especially if you want to go into a cooperation. And so we are thrilled to share with you what we, from our perspective, think are the most important things to realize, to think about, and how you can protect your rights in a very easy way. But well, that's not all, but I think we got the most important points. Well, before we start and going into the details, into the legal details, and I hope it's not too legal, and we want to say to you that we will later provide you with our presentation. And if you have some questions or something like this, please ask your question in the chat. Adam will catch them up, and later we can discuss about your questions, or maybe if you after that webinar questions got up. So please let us know. Come to us. You will get our contact details, and yeah, we can discuss on your points in an individual way. So, well, at first, who is speaking about? So, well, I'm Mareike German, a German lawyer, and here at Taylor Wessing, it's a big international law firm. And so we are working just not only in Germany, we are working worldwide, over 1,000 lawyers. And well, I'm advising my clients on IT and data protection and cybersecurity. And my colleague next to my room, Sebastian Fischöder, is also specialist in.
Yeah, so my name is Sebastian Fischöder. I'm also a partner with Taylor Wessing and based in Düsseldorf. And I'm an intellectual property attorney with nearly 20 years of experience in protecting, enforcing, and exploiting intellectual property rights. My first specialization is the protection and enforcement of unconventional trademarks, like color marks or shape marks. But much more interesting for you in this context is my second specialization. I regularly advise clients on how to protect their IP and know-how assets in commercial transactions and in technology cooperations. And what will we be discussing today? When we talk about IP, intellectual property, and know-how, we talk about the immaterial assets which are so vital for your business, for the technology and digital business. Those assets consist of intellectual property rights, which you may all know, like patents, utility models, trademarks, or designs, and particularly also copyright, be it copyrights in the software, products, or other, such as graphical work or artwork like graphical user interfaces. They can be copyright protected as well. We also talk about rights of use. This means rights you license in, so it's other parties' rights you license in, which allow you to use, for example, software or a technology. But also the titles of a software or an app application are IP protected. Likewise, databases. And of course, your immaterial assets consist of know-how. That's a very broad and, in a way, unlegal term. And know-how includes, but it is not restricted to secret know-how, such as business and trade secrets. And know-how is particularly important and tricky and critical, as often know-how is not protected by IP rights. Such know-how is solely protected by the fact of being secret. So you have to actively keep your know-how secret in order to keep it valuable. Last but not least, the rights, or what we are talking about, is assets, your assets, which may also consist of personal data, be it your own personal data or third-party data, which you lawfully use.
Yeah, and when we think about that all, we also have to talk about whose rights are at stake. So the easiest way should be, when you have an overview, if it's your own rights. Yeah, so you know, okay, the use is maybe limited or unlimited in a special way. You should have an overview what rights you have and what you can bring into a corporation. So that's maybe the easiest one. Then you will always, or especially in the IT area, you use very often rights of third parties license in. What we are thinking about when we talk about software, I think about open source software, because that is owned by all who use it. Yeah. And or we can think about standard software. For instance, some easy examples, Microsoft or SAP or something like this, and also maybe other properties software. So this is one part. Then maybe you use rights of your customer or rights of your supplier. For instance, if you use freelancer for software developing. And when we talk about personal data, so the data belongs to the data subjects. So you need legitimation to use them. Otherwise, it's illegal to use personal data. And then we have to think about, okay, when we have all that stuff, we know what rights we are talking about, we know who owns it, then we have further questions. And the next slide. These are the basic questions when we talk about a corporation. So the first thing is to discuss, when we want to go in a corporation, do we want to have a joint company? So we want to work together for years. Or do we want to have a corporation for a special project? Or for a third party, maybe for a common customer? And so that's the first thing we have to think about. And especially if we have a result from that cooperation, do we want to have a common product business, or do we want to use it for different products, for own products, just to only have the development together? And well, also an important point is, do we want to use it only in one country, within the European Union, outside the European Union, where USA, Russia, and so on, China, maybe. So these are the first things you have to think about, so that you know what you have to do later. And also, when you think about this, you have to think about, okay, I have previous results, so maybe I have software products in it. So do I want to use it for that common product, or should that be separate words, so that everything which is in the common product will be developed new? So, or if you want to have a common product with your cooperation partner, do you want to use your previous results also for own projects, so that it's not only used in that common project, for instance? And so these are only basic questions, you guess, but this is really important to think about. Okay, what contract do we need maybe later? What measures we have to do, and so you know how to protect it later during the cooperation. And further, the last thing for me is data protection. Yes, especially the last years with the GDPR, I think all you know it. A lot of legal risks and challenges. So when you use personal data in a common way, you have to think about it. Okay, do I have a legitimation for this? Because otherwise the processing of personal data is illegal. Are we both in a common way responsible for the personal data? Or is the customer maybe responsible for this data? Do I have all the security measures? And especially if we have data transfer outside the EU, then you have to think about, okay, outside the EU, it is assumed that there is no adequate data protection level in comparable to the GDPR. So you have implement such safeguards to make it an adequate data protection level. Otherwise, it's also illegal. So, and especially with Russia, that's a third country. And so you have to implement these measures, otherwise it's not allowed. So that's something you have to think about before you start data processing.
And for your IP and know-how strategy, there are two more very important issues you should think about and have a position on before starting a cooperation. The first is, what shall be the future regime over the so-called foreground intellectual property and foreground know-how? Foreground IP and foreground know-how means those IP rights and those know-how which you develop under the cooperation or in the cooperation. For example, a new software, a new technology which is patentable, or some other protectable, IP protectable in some other way. So make up your minds, together with your cooperation partner, who shall own the rights in the products, in the results of the cooperation. Shall the foreground IP be owned jointly by the cooperation partners, or only by one of the cooperation partner who pays off the other? Everything is possible, just make up your minds. Or it's also possible that you wish to transfer as much as possible of the foreground intellectual property to a third party, to an ultimate customer, for example. Or you want to retain the intellectual property rights and the know-how as much as possible and hand out licenses in return for license fees. So that's all the questions you have to ask yourselves and you have to answer for yourselves with regard to the structure of your cooperation. And the second important question is, are you the owner of all the rights and know-how necessary to be used in the cooperation, and for example, the ultimate product which you are about to invent or develop. In case you have to use third-party rights, you have to check whether you are entitled to transfer these rights into the cooperation and perhaps further to a customer. To answer those questions, you have to undertake an inventory. And this is no fun. You really have to do a sort of due diligence of what rights you have and what third-party rights you have licensed in, and what the conditions are under which you may use them, under which you may transfer them on to third parties or into the corporation. So this is all these are very important structural issues you have to think about before starting a cooperation. And I would like to illustrate how these questions and their answers structure your IP and know-how strategy throughout a cooperation. Please look at this example. Just imagine you a company wants to launch a new product on a worldwide basis. It shall be sold worldwide, and this product shall include your brand new, innovative, to be invented technology. And the customer expects to only deal with a single company. You are convinced that you have the skills to develop the required new technology for the client if you cooperate with a certain Russian company. What is now vital? You need a cooperation agreement between yourself and the Russian company. That's the place where to provide for who brings in which rights and which know-how, and what shall happen to the rights consisting in the new technology, the foreground IP and foreground know-how. And you have to take care that your know-how remains secret. This agreement is also a place where to deal with this. You need another agreement with the customer to transfer the necessary rights and know-how to the customer, which he needs in order to sell the new product. For doing so, for transferring the IP rights to the customer, you have to transfer the necessary background IP and know-how into the co-owned company. The background IP and background know-how is the intellectual property rights and know-how which pre-exists before the cooperation. So you have to transfer the rights into the co-owned company. And again, for doing so, you have to ensure that you and the Russian company has to ensure that it owns the necessary rights themselves, or that they are entitled to transfer, the rights and rights of use further on. And at all these junctions, you also have to ensure that your know-how, your secret know-how, remains secret. Again, make sure you have to make sure that you have all the rights and titles to enter into the cooperation, and that the cooperation is entitled to further pass on the rights and the know-how to an ultimate customer in this structure. And here is an example of what can go wrong. Just an example. Under German copyright law, the exclusive rights of use for a software are vested in the employer automatically, but only if the software creator is an employee and if he develops the software under the employment contract. Just recently, I came across a scenario where an unusually talented but otherwise simple warehouse worker in his free time developed a software tool for a company to manage the warehouse outlets. It was extremely valuable in use. But this software was not developed in the execution of the employment contract duties, but outside this contract. Hence, the employer was not entitled, not automatically entitled, to use the software himself, not to mention to transfer it further on. Also, if the software creator is not an employee, but a freelancer, Mareike mentioned it before, the transfer of rights does not work automatically. You need fairly clear language in your agreements. Likewise, in case of the very German concept of Scheinselbstständige, pseudo self-employed persons, if they create a software, the transfer of rights is also tricky. And this is where you can run into problems when you wish to transfer these rights into the cooperation, because you cannot transfer such rights of use into the cooperation if you don't have them yourself. And Mareike has another example of what can go wrong and what to look for.
So maybe, as you all know, when you have something to do with software developing, well, every software has open source components. And well, it's very useful and it has a lot of advantages because you can make a project cheaper, and you have a basis. Yeah. So these are the advantages, but also, you know, maybe all the risk, because the licenses, they give you some requirements you have to fulfill, and for some open source components, it's so when you want to use them, and especially if you combine them with your product. So if you develop the open source software in it, then you have the duty to license the new product you build with that open source component as an open source software. So that's called copyleft effect. And especially some open source components, they have the requirement that you use them and also combine them with another product. Then you have to disclose the source code. And so if you want to use your product or the customer, if you want to use the product as a standard software or as an individual software for him, so you can imagine that this is the worst case scenario, because this software must be disclosed. You cannot solve them. You must disclose the source code and so on. So the customer will claim you for damages and so on. So what do you have to do? You need a kind of software compliance system. So at first, you have to check what open source software can be used in your company or in the joint company with your partner. So, and then you have to say, okay, these software components 1, 2, 3, they are not allowed to use because of that copyleft effect or the barrier effect. And you must be sure that the software engineers are aware of that problem and that they only use the open software which is allowed to use for that common product. And so, you know, every software company has to do it, but very often I see it in my practical working in the ordinary day, that very often software engineers, they just use what they get. So this is a risk you have to be aware of, because if you want to use the product and to sell it, or if you want to sell it to a customer with a special kind of use, you must be sure that there is no open source software in it with these effects. So what needs to be done and to be sure that that the cooperation can work and that you can manage all the risks? And at first we want to talk about, I call it some basic and essential protective measures. And when you read it, you say, oh yes, sure, we have to do it. And we always do it, but very often in our ordinary life, we see, okay, some things, some points are missed or have to be renewed. So maybe the first point is to select a good cooperation partner. Yeah, that's the first due diligence you have to do. And you must be in line with them. You need a common interest and you common interest and common way how to work with each other, and you must trust them. So this is the first thing you have to do. And then please, before you start working, talking about something, please close a non-disclosure agreement. It's standard. It's just only one pager. It's nothing special from a legal point of view, but it protects you, because when you talk about ideas, when you talk about things, it's not protected in such way. Ideas are not protected, and especially you will discuss about things which might be protected. So maybe you will say, okay, this is my customer, or this is the idea, we have that product or something like this. So this is very important. As a basic rule, use a non-disclosure agreement. Then if you want to use people work together, so you will use and process personal data, be sure that you are compliant with the GDPR requirements. Of course, otherwise both have a fine risk, and so that's always a point you have to think of. Then you have to if you say, okay, we want to work together, we want to have that project together or product, or you want to have a common company maybe, yeah. So conclude a good agreement which contains the things you need and which is very clear and tells what you want to do and what is the aim of a cooperation. And finally, it's kind of factual confidentiality, so nothing to do with law. Just give your partner only the things you need to know. So the need to know principle, it's the best way how you can protect you. So that nothing had to do with law. It's just how to work with partners. And so when your partner does not know things, he cannot infringe you or your customer. And when you think about an agreement, then you have to think about, okay, what must be written in it?
Yeah, and that's where I come in again. Concluding a sound and safe agreement is key to protect your IP rights and your know-how in a cooperation. We collected the most important, of course, there are many more issues to consider, but we collected the most important points on this slide. And those are the points at least you wish to address in an agreement. So as in the example before, if you wish to create a separate legal entity into which you would like to vest the product or the result of your cooperation, you need a separate shareholder agreement to create such company. But nonetheless, also the cooperation partners between themselves, they require a cooperation agreement. And this agreement, that's the blue shaded stuff on this slide. This agreement should in particular contain, for example, a clear appropriation of responsibilities. For example, who is responsible for registering foreground intellectual property rights? Just imagine the cooperation brings about an invention which is patentable throughout the world. Someone shall be responsible for taking care of having that invention patented. Who shall own the rights? Shall they be jointly owned or sold to one of the cooperation partners or the other? Who has the task to manage personal data and to ensure that the legal requirements to deal with personal data are met? Who is responsible for the open source software compliance if necessary? You should address this as clear as possible in the cooperation agreement. Also, which foreground IP and which foreground know-how shall be transferred on to a customer, for example? Which rights do you wish to retain? Under which conditions do you wish to grant licenses to your customers? Do you want them to be granted territorially restricted, or do you want to grant them on a worldwide basis? Or also an important issue, do you want to have that cooperation for just a short time or until a certain aim is reached, or is it for many, many years? Do you want to join businesses, essentially? All this has to be provided for in the agreement. Also, very, very important, always anticipate the failure of your cooperation. What shall happen to the IP rights, to the know-how, to the foreground IP rights if the cooperation ends? This is very important, and you should clearly address it in the agreement. Things work well when you work well. Once disputes start, you will end up in trouble, and then that's the time where a good agreement helps. Please also be aware that the transfer of know-how can be liable to competition law restrictions. Within the EU, there is an exemption regulation on technology transfer, which may apply. That's a good thing, but if it doesn't apply, you have to meet competition law requirements. Also, in the agreement, think of liability of the cooperation partners, in particular for defects in the background IP. Just remember that if you aren't entitled to use a certain software and to bring it into the cooperation, but you did so, then you may end up with a damages claim. Who shall be liable for that? That's scenarios you have to address in the cooperation agreement. Also, very important, provide for mechanisms of enforcement and escalation in the agreement. You can agree on contractual penalties for breach of contract. You should agree on dispute resolution mechanisms, be they between the parties or before courts, or you can agree on arbitration clauses. You should think about which law shall govern your cooperation, and in case you wish to bring actions, where can you bring them? In Russia, in Germany, in another country, if you wish so. Think about that. A very important issue, and Mareike has highlighted it, and I again highlight it, confidentiality and non-disclosure. This is very important. And it's particularly important for know-how protection, because much of technical or commercial know-how is not as such protected by an IP right. As mentioned before, the protection of know-how is a fact it's protected because of the fact of its secrecy. So you wish to keep it secret. Once it's out, the know-how is gone in a way. At least it's not your know-how anymore. So particularly with regard to know-how non-disclosure clauses, you may also wish to think about separate contractual penalty clauses in the agreement. Finally, also think about the termination of the cooperation. Under which conditions shall the cooperation partners be entitled to terminate the cooperation? And what are then the obligations of the partners? Do you want to retransfer the rights? And again, distinguish between the background IP and the licenses into the cooperations and the foreground IP, the results of the cooperation. And in particular, think about which obligations of the cooperation partners shall survive the end of the cooperation. And this is particularly important for the non-disclosure obligations. They should last eternally, if possible. Yeah, and this brings us to the end of the presentation. Mareike.
Yeah. Well, some of our key messages. Well, at first, sure, think about the aim of a cooperation, but also think about your interests. So what do you want to have to deliver, and what rights you wish to retain? So this is in your interest, and so that's the first point you have to think about when you want to enter into a cooperation. And then make sure that you can use the necessary rights you need for the cooperation, or you wish to need, and otherwise, when you see, okay, I'm limited in that way, maybe you can first close contracts with your customer or with your supplier to make it possible to use them later in the cooperation. And well, protect yourself and treat your know-how and the personal data as strict as possible, so on a need-to-know basis. And so just to protect yourself for future and during the cooperation. And now the last points from...
Yeah. Being the contract guy, anticipate exit scenarios. I've elaborated that before, but again, that's the key message. Anticipate the failure of the cooperation. Non-disclosure agreements are key, in particular for know-how. Good agreements are nasty. They need preparation. You have to do your inventory. They need negotiations, which can be exonerating, and they need expertise. Perhaps you have to pay attorneys and pay for legal advice. But good agreements help so that you can inventive on what you can do best, being innovative.
I agree with that. Thank you very much, Mareike. Thank you very much, Sebastian. Very, very precious insights, actually conducted in a very classical way, but we got a perfect guideline. And first of all, the non-disclosure agreements, working in IT and deep tech startups, I can tell you that this is a classical example when actually companies fail to agree because of a non-disclosure agreement. Of course, this technology, first of all, the reasons I can tell you is sometimes that companies are afraid that co-working companies that are working with them can actually say a word sometimes around what is going to be developed and can actually leak to some competition. So I think these agreements are very crucial just at the beginning of a cooperation, especially if you invest the time, money, research, and manpower into deep tech companies. So I think it's much worth to invest in a good attorney, some legal advice, exactly from such specialists like Mareike and Sebastian. So don't hesitate to ask them. I'm gonna ask you some questions at the end. If you don't mind, we're gonna proceed with the next presentation. Okay. Mm-hmm. So at the end, I'm just gonna have 2 or 3 questions regarding what is actually going to be the main think about it. So thank you very much at the moment. And let's proceed to the next speaker today, who is going to be Karolina Baralkiewicz-Sokal, attorney at law, at partner at Fonsantier & Schulz in Poznań, who is going to give us an update about the IP protection here in Poland, also in EU, but with some actually twist on that. Hi, Karolina.
Hi.
Exactly.
Hi.
Hi.
See my presentation now?
Yes, we see you and we see your presentation.
Hello.
Great.
Hello,
enjoy. Yeah.
Thank you very much for presentation and for invitation to this event. I am very happy to be here, and I am very happy to lead you all through the Polish IP law within 20 minutes, which is quite challenging. And what I can start with, I can sign with both hands under all information and tips you received from the presentation before me. They could be also mine, so I go forward with Polish side. My name is Karolina Baralkiewicz-Sokal. I'm attorney at law and partner at the Fonsantier & Schulz in Poland, Poznań. We are a company, legal company, Polish and German, so we are active in Berlin and in Poznań, and we advise as well as in law and taxes in all languages, Polish, English, German, and under motto, your success is our goal. If you have any questions to my presentation, you can write it in chat and Q&A point or ask them at the end. We are also here for you, ready to answer questions also after presentation. You will receive all documents with our contact data at the end. Yes, I was thinking how to say it for this short time. So first of all, you have to find what are the legal acts which you need to think about IPR in Poland, and these are acts what you see on my presentation. It's not all, but it's something which gives you a start to work with these rights. What can be protected in Poland? We have three points when we start developing something new. We have an idea, we have a final work on a base of this idea, and sometimes we have so much luck that we have an innovation, and how to protect all of those things which can be an effect of our work. First of all, an idea. It's a thing which is not covered with protection. It may be covered by the act of fighting of unfair competition as a know-how of a company, but it's not strong protected. That's why it's very important when you have an idea to change it as quick as possible into something what can be protected, or if the idea is as know-how, to implement such legal instrument to protect it and to give it to someone else only then when you are sure that it will be used as you wish it. So an idea is not very strong protected. Then we have a work which is protected with copyrights. You have to be aware that not everything is a work, so not everything is protected, but you can still think about making those things which are not protected into protected part of work by describing it, by putting it into form which is under protection. And then you have the nicest point of your work, an invention. So when you find a new solution which is new, which is so inventive that no one else had found it out before, you can try to protect this as a patent, and it's a very strong protection. As you probably know, you can try to protect this European-wide, Poland-wide, or worldwide, and you can start working with it. As soon as you register a copyright, or you have a copyright or register a patent, you of course can transfer it to your partners, to your business partners, in two ways. So you can transmit it all, or you can give your consent to use a part of it or the whole. Of course, you can also have in your mind that some future inventive solution may be part of a transfer agreement. Of course, in such a case, always think to protect your rights, not give to your business partner any information before you are sure that your rights and your confidentiality is secured. So when we transfer copyrights, we have two possibilities. We can sell it all or donate it all if you want to. Important is we do it in written, and we define which part of those rights are a point object of the transaction. It's very important to know what part of your knowledge of your work you give further to your partner, and that's why a written contract must be done here, and the contract, it's very important to think particular what's inside. That's why we always recommend, on the basis of our experience, to find a lawyer or find some specialist which will help you to define points which are important for you and which protect you in the future. Of course, you can also transmit a part of your rights in case you give a license exclusive or non-exclusive. It's also very important to define it, first of all, for yourself, what part of it you would like to transfer, what part of it you would like to give someone to use, and then to describe it in the contract very carefully to be sure that in the contract there is written exactly what you want to have inside it. And then the same thing with a patent. You can also sell it or donate it as a whole part, also in written form, but don't forget the protection is only for 20 years. So before you start buying it from someone, check it out when the protection has started, to be sure that your investigation in this part of intellectual property is exactly for the kind of period which you need, and that it protects your rights for a time which you imagine. You can also transfer it in a part, so you can give a full license or not full license, exclusive or non-exclusive. It's also very important just to sit down in your company and think what you want to do. Maybe you have an idea to make a company with your partner and use these rights together in one company as a shareholders, or maybe your idea is to give a license to 2 or 3 other companies which will work in it. It's very important. Think about it, write a good contract, and be sure that in the contract before signing there is everything what you imagine and what you want to have inside. And now we come to a little bit difficulter part, because we also have know-how, which is not registerable, which is not stately protectable or worldwide protectable, and which is very often with the same worth as a patent, but it's not inventive. It's not the first invention, it's not the first thing, it's not the only one, and it's not completely new. But it has its own features, and it's very important for you. And you want to use it, you want to implement it into commercial life, commercial environment. So you define your know-how, you define what you have, you define your intellectual worth, and then you start talking with your business partners about selling it, about giving them the knowledge you have or you invented. It's not only intellectual, sometimes it's also an idea how to build something, how to write a program, how to use it, or how to implement it. So the first thing what you have to keep in your mind when you start negotiating or talking about know-how agreement is confidentiality. And don't be afraid when someone tells you, okay, nobody signs it, why do we have to sign it? We know each other for so many years, so we can work on a trust basis. Okay, trust is very important, as the presentation before said it. And I'm also of the opinion that you have to work on a trust basis. Trust, but also sign confidentiality agreements. And then when you are so far that you sign an agreement about know-how transfer, think about it. We will finish our cooperation someday in the future. What about our know-how after finishing the work? Would it stay in the implemented form at my partners? Would it go to me back? How can they transfer it to a third party? What can I do with my know-how after finishing this contract? Can I use it again for another partner? Those are questions that you have to ask yourself, sign them down, and discuss with your partner. And think about confidentiality and about all important things for you to protect your idea, your know-how, that it does not go away from you before you sign an agreement. That's how we come to another point, because non-confidential is important during the corporation, but it's also very often a situation that you have an invention, that you have some idea, that you have some know-how, but it's still in your company. It's still not registered, for example. And you look for business partners to implement it, to improve it, maybe to work on it, to find an idea how to use it. And when you start with discussions, it's also extremely important to sign this agreement. It's and don't let yourself don't listen to business partners who say we don't need it. We worked so long together. Even we, as attorney at laws, sign NDA agreements in particular cases. And think of you in this small point when you start discussing discussion about selling your invention, your product. So think what you want to protect. It's the subject of agreement. Think how to treat the confidential data. It's not only data concerning your invention, your know-how, or your work. It's also personal related data of the persons who work on a project. It's also personal data of eventually third parties. Here we have 3 countries, 2 countries which are UA members and Russia. So think about personal data between countries. It's very important to have it, keep it in mind. Then think about consequences if someone will break a confidentiality agreement. What can you do? How can you do? How expensive it will be for the other contract party? How can I come to realization of these penalties which are in a contract? Think for how long do you want to sign this contract? How important are the data for you? When can the other party use the information which they received now? Should they keep it for them for their whole life, or can they talk about it after, I don't know, 10 years or after some event? And then think about law and jurisdiction, because if you work between 2 countries, there is always question, okay, no, we can't work anymore, and we haven't written which court and which law, and now we are not sure whether it's Germany, Poland, maybe both, maybe Polish court and German law. Oh, so better think about it before and write it down in the agreement. Then it's also important to think about non-competition, because we are all business partners, we all work together, we all have the same aim at the very beginning, and hopefully also to the end of our cooperation. But it also may happen that something goes wrong, and someone says, okay, I don't want to work with you on this project anymore. I have a part of my know-how, and I use it with other partners. So think about it to make them this decision, the steps more difficult. think what is not allowed after finishing cooperation with you, or under which possibilities it is allowed, whether you will pay the person something for non-competition or not, whether it's necessary, legal or not, which penalties for breaking the non-competition clauses. It's very important to think about it. And here we come to a subject which I haven't prepared in my presentation, but I think it's important to tell it now. Employee-employer relation, because it's also a little bit different than to commercial relations. Concerning copyrights in Poland, it's the same as my colleagues before said about Germany. And remember, when you sign a non-competition clause with a Polish employee, you have to pay for it. And you have to pay for it at least 25% of his last salary. And if you don't sign in a non-competition clause, this salary, it will still work, but the court will tell you pay for it. So it's very important to know it. If you sign non-competition with an employee, you have to keep in mind that it costs something. And now, last not least, but it can happen that you have to go to a court. But you work together, the process goes and it goes well, you understand each other, but you came to a point where it's not possible anymore. And even if you try to find a settlement, it doesn't work. My advice for you, and I would like you to take it home with you from this meeting, is good agreement with very precise, prepared regulations. So when you read it, when someone who is not a lawyer reads it, it's clear what are the obligations of parties and what is to do when the cooperation ends. Because a legal proceeding is always expensive and always takes a long time. In Poland, we have only 5 courts which deal with IP problems, so it may take a lot of time. So you think now probably, okay, at the court it takes a long time, maybe we will sign an arbitration. Arbitration is not bad. And my experience, I had a very big know-how process in the front of arbitration court in Warsaw, which has finished in 1 year. So very, very quick for a court proceedings. But when you check arbitration and you decide, okay, we choose arbitration court, please check before how expensive it is to deal in the front of this court, because it can occur that you will not go to a court because it's too expensive. Okay, so take with you 3 points from this meeting and I will be happy. First of all, good partners which you trust. Second, trust but sign NDA agreements at the beginning of your work. And 3, prepare the contract as good as you can. Ask people who knows it and be prepared for each possibilities, bad or wrong. It will allow you to make good deals and work with exact partners. So thank you very much. If you have any questions, just ask them in the chat or at the end of the meeting.
If you have any questions, exactly, don't hesitate to ask us via the chat or afterwards. We'll be recording this great presentation. Thank you, Carolina. Again, we come into the NDA, which is going to be crucial for us. So once again, Carolina, thank you very much for your precious insights. Greetings to Poznan, to Poland, and let's have a look at what is actually going to be the challenging comparison with our next partner from our Russian module. Our next speaker today is going to be Maxim Mikhailov, Head of Legal Department at Soyuz Patent from Moscow. Let's welcome you on the stage, Mikhail. And Hello, very warm welcome.
Hi.
Greetings to Moscow. And yeah, this Soyuz Patent is a very, very famous organization who has been actually given patents to since 1923. One of the biggest enterprises in Russia are legalized in deep tech as well. Maxim, could you please explain us how our cooperation with you could look like and what are going to be the insights? Let's start.
Thank you, ladies and gentlemen. I would like to welcome you to a short presentation on IP and know-how in the context of cooperation, international cooperation, and cooperation with Russian partners as well. First of all, I would like to say that in Russia, we have an exhaustive list of, just a moment. We have an exhaustive list of IP objects, and when cooperating with Russian partners, it is crucial to keep in mind that objects which are not enumerated there may be deemed by Russian courts in case of a dispute as something contrary to public order. Therefore, before starting any cooperation with Russian partner, we strongly recommend to review this list, and in your cooperation agreements, in your joint ventures, please try to use the umbrella terms close or similar to those which are stated in the exhaustive list in the Russian legislation, in order for them to be protected in court in case of a dispute. I was asked by the organizers to give specific attention to protection of know-how. Under Russian law, know-how means any information, including technical, economical, organizational, and maybe some other information which has real or potential value due to being unknown to the third parties, and to which third parties do not have legal access. Also, there were some changes to Russian legislation, and as of the current date, you need to introduce confidentiality regime in order for know-how to be deemed know-how, basically, in court, and therefore to be protected. Before these changes, you had to introduce commercial secrecy regime, which is regulated by specific legislation in Russia, and which is quite cumbersome procedure. Commercial secrecy regime is regulated under specific legislation, includes making specific cupboards which should be closed, the keys should be stored, there should be some people who are responsible for keeping the information confidential, and some other cumbersome procedures, including internal documentation. Now the regime has been a little softened, and you do not need to follow this commercial secrecy law, but you need to introduce confidentiality regime, and steps may be different. Usually such steps include some technical procedural measures, making markings on the documents and emails, Also, it is important to include in the documentation with your employees or contractors the provisions on confidentiality, because in the process of cooperation, in the process of joint venture, there may be some improvements to the IP which you exchange with Russian or international partner. In particular, this may lead to the situation when some relative or some friend helped Russian employee or contractor who is involved in joint venture, and afterwards such third party outside your joint venture may claim authorship or even IP rights to new improvements to IP. We have seen such cases in Russia. So to make sure that nobody except previously agreed list of people claims IP rights to joint ventures IP, please keep in mind that employees, contractors should be covered by confidentiality in their contracts. There are, of course, certain other peculiarities relating to know-how protection in Russia. The list of information which can be protected is not regulated, so it's quite wide range of information. Any type of information can be protected, almost any type of information except widely known. However, when you exchange with your partner in Russia with know-how, specifically with know-how, because it is not registered object, I mean, like patents, utility models or designs, you do not have a state registration number and publication in the public access. So you cannot compare what you agreed in contract and what exactly was handed over as a result of transaction, as a result of joint venture. For example, you may state in the contract that you transfer to the joint venture on your part. You transfer some methods of hiring personnel, and you even give them a number and a list, and probably when negotiating the joint venture, you probably even showed to your partner, or your partner showed to you how it looks like these methods of hiring personnel, or you sort of scrolled through the specific brochure or file on the computer, and you agreed on that. You said, well, that is of course of value and we need that. But in the contract you wrote something like methods, one line, etc. When the joint venture is made, eventually you receive something different. Not probably different at all, but not exactly to what you sort of counted, on what you counted, and the value of what you received may not be less, may be less than you initially planned. So in Russia, we usually have court disputes regarding the identification of transferred information, the identification on what has been agreed and what in the end people received. How can this problem be solved? Two ways, basically, maybe three ways. The old-fashioned way is a hard copy of the materials. So when signing partnership, you just enclose hard copy, and that's it. If it's possible, or probably some flashcard with written materials, but that's a rather different story. You may also use qualified electronic signature to identify materials, and some cloud services using the payroll word, password words, and some other specific means. But what is the main message of this is that you should pay close attention when working with your Russian partner on identification of non-registrable IP objects. Also, it is quite difficult to prove losses when the contract is breached, the information is disclosed. First, you have to prove standing, that is your know-how. After you have proved the standing, you have to prove that the damages you fixed in the contract correspond to reality. And Russian courts apply very strict tests to underlying documents. If you even if you fix an amount in the contract, the court has the right to reduce it if you will not be able to sort of prove that the damages are of such and such an amount. Also, I would not recommend to rely on insurance mechanisms. I have seen the joint ventures when a foreign party obligated Russian party to enter into insurance contract, and in case of damages to disclose, such insurance company will compensate for the losses of a foreign counterparty. First of all, it's quite difficult to find an insurance company which would take such obligations. Secondly, if the amount is quite difficult, Russian insurance company tend to wait for court decisions before they pay. And in court, you will have to prove that what has happened falls under the definition of insured event, which is also quite difficult. Maybe it's just a moment. Well, one more point which I would like to draw your attention to: if your partner or you in your cooperation, in your joint activity, involve employees and contractors, you have to take into account Russian law specifics regarding the IP which they create and to whom it belongs. If an employer creates an IP, provided that the employment contract states the obligation to create certain IP, then IP will automatically belong to the employer, so to your partner or to you. Otherwise, totally different situation is when you involve somebody to work as a contractor. In this case, IP will belong to a contractor rather than you. And when making a joint venture with a Russian partner, please do not forget to include in the agreement the obligation of Russian partner to include in the agreement with its contractors the provision to the effect that all IP created by contractors should be transferred to your Russian partner. This default provision, I mean the provision relating to IP of contractors, may be changed by contract. So if your Russian partner makes good contracts with its contractors, the IP will not be lost. It will be legally belonging to your Russian partner and to your joint venture. So there are a lot of such small issues, seemingly small but very important in the end issues, and therefore we recommend to sort of have a small, at least, umbrella consultation before going into Russian joint venture. Also, as the conference is concentrated on software, our firm actually is dealing with software protection, and software protection is in Russia quite specific again. Pure computer software is not patentable. It is protected as copyright in Russia. And software inventions may be protected as a conjunction of hardware and software as a kind of unit or a method or a kind of improvement of hardware. We would like to draw your attention that in order to protect the software as invention, you need to follow the following recommendation. Indicate technical result in the description, provide detailed explanation of implementation, variations of the software in the description, provide example of realization devices, system, or the like, with claimed software in the description, and in claims, please indicate objects relating to device with claimed software, method realizing by the device, or the computer readable medium storing the software. This is the gist of our practice. We always try to help our clients, and sort of speaking of liability for know-how infringement, there are three types of liability. This is civil liability, which is injunction damages or contractual penalty. But as I said, damages are very hard to prove, and the injunction is also a very rare case. Administrative liability and liability arising from the anti-monopoly legislation, and criminal liability for the illegal disclosure of information constituting commercial secrecy, commercial, tax, or banking secrecy. But if we speak of criminal liability, again, referring to my first remark, commercial secrecy, according to the commercial secrecy law, should be introduced. If commercial secrecy law is not complied with, and just a certain confidentiality regime, softer confidentiality regime is made for the purpose of know-how protection, then criminal liability will not apply. Well, basically, that is it. And if you have any questions, I will be happy to answer them. Thank you very much.
Hello, thank you very much for these precious insights about the regulations on the Russian market. If there is any questions, I would like to answer them. Do I see anything from our participants? Not really. So I would like, first of all, to thank you very much to all of our speakers and to this precious insights about the non-disclosure agreement and about our guidance, which was provided for us when developing those partnerships. If you're interested in participating in some matching formats, I've got some good examples for you. So I'm just going to share it with you on the chat. There's a conference about IT and cooperation between Poland and Germany, which is taking place in the next weeks. And the same is actually, we have our matching event for founders from our startup accelerator. So I hope that you can actually take part in that. And I'm going to share this link with you as well. But first of all, I would like to have some questions to our speakers. And thank you for participating here. And Sebastian, exactly. You emphasized that the know-how protection is different and somewhat more tricky than the protection of IP rights. Can you please explain in some more details about this question, about this issue?
Yeah, do you hear me?
Yes, we can hear you.
Thanks, sure. And I think you touched an important point there, and our colleagues from Poland and Russia have also elaborated on that. I think that the main difference between IP protection and know-how protection is that IP rights are protected by law in a way against use without the consent of the IP holder. And so, for example, if your cooperation partner uses your patent or your patented or your copyright protected software in a way which breaches the agreement, the rules you agreed on in the contract, then you can go to court and request the court to order an injunction and make him stop using the patent or the copyrighted software. So this is very different in case of know-how. Much of the essence of technological or commercial know-how is not subject to any specific IP protection. And it is in the nature of the knowledge or information that once it is out there in the world, you can't get it back. You can't, it's in the head of someone else, and
exactly.
Actually you don't really want to cut off heads of other people. So that's a very factual thing. It's in fact difficult to protect know-how. And of course, Maxim and Carolina, you also mentioned that in your jurisdiction, there are know-how or trade secrets which which are afforded special protection by German law or Polish law or Russian law. But that's in Germany, for example, the Geheimnisschutzgesetz. But this sort of protection, this know-how protection, requires the protection owner to keep the information secret and confidential, and to take appropriate measures to keep it secret. And that's why, and one of those important measures are non-disclosure agreements. And that's why we all, I guess, keep telling you guys, think about non-disclosure agreements. They are very important. So even if your knowledge may qualify to be protected under something like the Geheimnisschutzgesetz, you really don't want to argue this in court whether you really met the appropriate or took the appropriate measures to keep it secret or not. So that's why we strongly advise keep it secret, and particularly keep it secret by practical means. Act on a need-to-know basis with your cooperation partner, and in particular with your customers. But good question.
Good question comes also from our audience regarding, again, the non-disclosure agreement. How long should our DNA be not to be abusive? So actually, yeah, is there like a proper answer about it? Is there like a short list of an NDA? I think it regards which points are the most crucial in the technology which has to be agreed about it. I think this is a question to all of you. Carolina, start. Microphone,
yes, okay. It's not an easy, because it's always case adjusted question. Because I think, Pablo, when you think about NDA agreement, you have to start from a question: what do I need it for? Who is my partner? What would I like to have from it? And then discuss for how long you want to have an NDA agreement closed. There are some secrets which are secrets for the whole life, I would say, and you have to just sign what points for how long you want to keep secret and what penalties are in it. My idea would be to keep it secret for all time as a commercial secret of your company. If you sign a contract finally after your negotiations, of course the NDA is not needed anymore, because the other contract party is the owner of the rights you sold. But it's there's no one answer for this question, in my opinion. You just have to adjust this to a particular case and think about all points which you have, and then decide for how long you would like to have it. Thank you.
Maxim, in your experience.
Excuse me, just can you repeat the question?
The question was, how long should be a non-disclosure agreement in order not to be abusive? If there is, in your experience, some good examples about it.
Well, in order not to be abusive, I do not see the agreement stating that the confidentiality obligations should be kept until the existence of know-how. I do not see that it is abusive. I have sort of no reason in mind why should be limit like 5 years or something like that, until it is disclosed.
Until it is disclosed. It's a good answer, I guess. Exactly. So maybe I have another question actually about the Sebastian, you mentioned that the transfer of rights of use for copyright protected software from the software creator to the employer. Do the same principles apply to the transfer of rights of use for other copyright protected items?
Again, a good question. And I think our colleague from Poland and Russia also dwelled on a similar issue under their jurisdiction. So basically, no, for other, or by way of example, what I talked about before was the copyright protection of software. The creator of software is afforded under German law a lesser degree of protection if he is an employee working or developing software for his employer. In that scenario, the law says the rights of use of that software go automatically to the employer. So with regard to other artwork or copyright protected items, such as graphical user interfaces can be copyright protected, or artwork which is used in software or produced, so can be copyright protected. The creator enjoys a much higher degree of protection. His rights, or the right of use, is not simply signed away to the employer just by the fact that he is an employee and works as an employer. In these cases, we always advise our clients to use very clear and explicit language, even in employment contracts, if they want to have rights transferred. And also there are usually remuneration issues which should also be addressed. So you better explicitly address this issue. But generally, different principles apply, and creators of software enjoy a lesser degree of protection of their rights than creators of other copyright protected items.
Anybody agreeing with that, Carolina, Maxim, or Mareike, or disagreeing with that?
You better agree.
Mareike, we cannot hear you.
We agree.
Mareike, your microphone, as we cannot hear you.
So
oh, exactly.
Now, okay. So maybe I want to add one point from my IT law perspective, because yes, that's right, that it's as a less protection as software engineer, but we also recommend the employee to have a special right of use clause in the employer contract, because if very often the software engineers, yeah, they are freaky, they like to work also on weekends and something like this, and then you have maybe the discussion: is it a private or way they developing the software, or is it just during their employment relationship to the employer? And so that you do not have all that discussion, is it maybe private or not. We also recommend to have that special clauses with the employee, although you have a law on your side. But it can be that then you have a lawsuit, yet then you have to deal with it, and so you have much less problems in your practical way. So.
Okay.
Add on one point regarding contractors. I believe employees is one thing, but the contractors is the other. I'm sure that in other jurisdictions it may be similar to the Russian regulation, as we give the IP to contractors rather than to those who hire them. Unlike employees. Employees' IP is transferred automatically to the employer. Not the same with contractors. Please keep in mind this peculiarity, but that can be changed by contract. Therefore, you sort of need to have at least a small consultation before entering in specific jurisdiction. Thank you.
Okay, last but not least, I wanted to ask you, all of you, like this point which was mentioned and briefly touched in presentations many times about data protection. There is currently a lot of discussion on the subject of data transfer outside the EU. And we have to also see that there is this German term on data protection, Datenschutz, but there is also this idea actually that many countries don't see the data protection as Datenschutz in this German term, but actually as data security, Datensicherheit in German. So what needs to be considered here? What is your opinion about it? Who wants to start? Who is the volunteer? Marika. Okay.
So, both, because it's the two topics, they're coming more and more together. If you have security measures which protect personal data, these measures also protect your know-how and other business informations, which are also very important. So, and also, if you want to transfer data, it must be a secure transfer. Yeah. So you have to keep both in mind, and especially if you're working for special customers, maybe because they can be or special security laws can be applied on them. For instance, the IT security law in Germany, it's also based on a European law, on a regulation. So I think in other countries, there are also laws like this. So you have both in mind, and especially if you have data transfer, then you also have in mind that you need an adequate data protection level on both sides, just to be safe from your side, and also if you use them for a customer, because then he has also the risk of fines.
Any other opinion or experience in this area? Carolina?
Okay, I would add one point, because we are all here European regulated concerning personal data, and we also have a regulation what happens if we transfer those data outside of Europe. By all implementation of personal data regulation, which I have prepared for my clients, I set two advices, and I think you also can keep it with you as for future. One is good documentation, so all rules which are written, which are to find from everyone, good training for people. But the most and the weakest point are people, are we, because we deal with those data. And we have to think about it. So we have to keep in mind when we transfer data outside of our company, of our environment, we have to check whether it is allowed, whether you have particular consents of persons and of other companies, and just to check it all the time, just to prepare it properly. So when you sign a contract, that's what we all said in our presentation. When you sign a contract, think about it, make a small point, personal data, and try to prepare your programs, your computer programs, in such a way that when someone agrees for transfer, he agrees for all possible situations which might happen. Okay, so thank you. It's from me so far.
Maxim and Sebastian, one last word.
Regarding the personal data protection, some of our companies are voluntarily complying with UDPR rules, but basically Russian government has a specific eye on personal data protection, and some world giants like Facebook had to allocate their servers in Russia in order to comply with Russian legislation. As far as I know, in certain transactions, like in financial transactions, when you transfer payments under loan agreements, you encrypt the data in such a way that it cannot be exactly deemed personal data outside Russia. And also, there are certain contractual agreements of the clients which should be by default incorporated. So, of course, we do have certain peculiarities, and it is quite a broad issue in Russia.
Sebastian, anything you would like to add?
No, I'm very happy that we are very specialized at Taylor Wessing, so I don't have to think about data security and data protection.
I'm also very happy about that you took part in this very, very professional workshop today to our audience, and on this very ugly day in Berlin. So big greetings and big thank you to all of you from different parts of Europe about it. And to all our participants, I just wanted to mention that our key messages today were to make sure you know what you have to deliver and what rights you wish to retain. Make sure you have the necessary rights of use and licenses in place. Treat your know-how and personal data strictly on a need-to-know basis. Anticipate exit scenarios. Non-disclosure agreements are key, in particular for know-how, and good agreements need preparation, negotiations, and expertise. And of course, these experts were here today with us. Thank you once again, Maxim, Carolina, Mareike, and Sebastian. This is going to be recorded and it's going to be posted on our YouTube channel. And I wish you a great evening. If you have any questions, we can actually have a chat in the networking lounge. Have a great evening. Take care.
Bye-bye.